Okay, Kabb.
Okay, I'm just trying to see what we haven't covered. Okay, so it says staying up all night on Shavuot night. It says here, okay. Many question whether a person who remains awake the entire night is obligated to wash his or her hands in the morning. The common practice is to wash one's hands without a bracha. However, if one uses the bathroom prior to washing, one may recite the bracha of Al Nitilat Yadayim. A similar question exists regarding the Birkat Torah, the brachas of the Torah. Common practice is to fulfill the obligation by answering Amen to the brachot of one who did sleep. One should not recite Amen after the phrase La Asok B'divrei Torah, but after the entire paragraph of V'ha'arev na is completed. It is likewise unclear that whether one who remains awake all night may recite the brachot of Elokai Neshama and Ha'amavir Sheina Me'enai. Yeah, as well as common practice to find someone who slept the previous night and didn't stay up the whole night, answer Amen to his individual brachas. Amen following Ha'amavir Sheina should not be said until after the bracha that concludes the Yehi Ratzon. Okay, those who daven at sunrise, or another term is called vatikin, should not recite a bracha on the talit before the halachic time known as Mishe Yakir. Rav Moshe Feinstein states that in the New York area, this is approximately 35 to 40 minutes before sunrise. Because of this concern, the Bnei Yisachar recommends waiting to don the talit until the completion of korbanot. This is there's prayers before Baruch Shamar, in order to ensure that one doesn't don his talit and make the bracha too early. Okay, and then it says, if one does stay up the whole night, you're not exempt from saying the Shema and davening Shmona Esrei at the correct time, and missing out on the bracha doesn't exempt you. You have to still say it at the correct time. So then it talks about one last point here. The dairy on first day Shavuot, the custom is to wait after eating hard cheese before eating meat. Hard cheese includes the types that are aged and somewhat sharp. Okay, but some people differ with regards to the definition of hard cheese. Anyway, okay, so that's let's leave it at that. But in terms of rather ask a Rov if you're not sure. If you happen to stay up the whole night, just ask a Rov, just in case. But I don't know if any of us are going to be staying up the whole night. Damon, maybe you will.
No,
Gavin?
12:30, 1, probably.
Okay.
Okay. All right. Let's get started, guys. Now, basically, the Gemara challenges Abaya's position from our Mishnah. We learned in the Mishnah, our particular Mishnah that we just covered, that if the fact that one stole an ox or sheep was established by the testimony of two witnesses, and the fact that he slaughtered or sold the stolen animal was established by their testimony as well. In other words, what we're saying, it's a single pair of witnesses that testify to both the theft and the slaughter or selling of the stolen animal. And they were then found to be zobamim, which is conspiring witnesses. They pay everything. In other words, the entire fourfold or fivefold payment. So what does actually that comprise of? Firstly, you have the kefil payment. According to the verse, he shall pay double. So the kefil payment is a kanas, it's a penalty. And that's for him, that's just being exposed as omimim for the theft charge, because if you're accused of theft, you pay double. Now, the additional twofold, if it's a sheep, or threefold payment for an ox, that's because they were exposed as conspiring witnesses on the slaughter or sale. So that's how we get the total number of payments. Okay. Now, is not the Mishnah referring to a case where, let's look at the order. They first testified about the theft and then testified again about the slaughter. That is, they didn't testify about the theft and slaughter at the same time. Rather, let's use an example, guys. They testified on Tuesday that they saw a theft occur on the Sunday, right? And then they testified on the Wednesday that they saw the thief slaughter or sell the stolen animal on the Monday. So notice the separateness of time. And they were subsequently rendered Zomamim with respect to their testimony on the theft, and they were then rendered Zomamim with respect to their testimony on the slaughter. So what we are saying is 2 witnesses came on Thursday and testified that the first witnesses were with them elsewhere on Sunday, when the theft is supposed to have taken place. 2 more witnesses then came on Friday and testified that the first witnesses were with them elsewhere on Monday, when the slaughter sale is supposed to have taken place. So you see from this juncture that the statement in terms of theft and slaughter did not happen on the same day. Now, if it should enter your mind that a Zomaim witness, a conspiring witness, is disqualified retroactively from the moment he gave his false testimony, then these witnesses, since they were rendered conspiring witnesses on their testimony regarding the theft, it's been retroactively revealed that when they testified about the slaughter, they were actually disqualified from testifying, because once it was proven on the Thursday that they testified falsely on the Tuesday regarding the theft, it's been established that from Tuesday on, they were no longer qualified to serve as witnesses. So their testimony on Wednesday regarding the slaughter didn't constitute testimony by witnesses, according to Rashi. So the question is, why then do they pay for being exposed as Zomamim on the slaughter? In other words, the punishment for Adam Zomamim applies only to witnesses who gave false testimony. So where the witnesses were disqualified at the time they gave their testimony, they are not subject to Hazama penalty. Okay. So what is it you think I'm saying, guys, just to test you? It's 2 points here.
You're asking the wrong guy tonight, sorry.
All right.
Kevin, I'm in a bad space. Is that Kevin Cross?
Hazam, okay. Well, maybe it's the second point, the Hazamna.
No, Hazama is basically the actual statement placing the witnesses at a different location. So that's the process where the second set invalidate the first set. So what we are saying is as follows, is that why firstly we said, look, this did not occur in one juncture. Okay, that's the first thing to bear in mind. In the example I've given you in our Mishnah, right? What's happened is that they didn't testify about the theft and slaughter at the same time. It wasn't on the same day. So, for example, they testified on Tuesday, Kevin, that they saw the theft occur on Sunday. And then they testified on the Wednesday that they saw the thief slaughter or sell the stolen animal on the Monday, a day later. So that their testification occurred one day after another, corresponding to when the theft or slaughter took place. So then what we're saying happens is that 2 Zomamim came on the Thursday, and they testified that the first witnesses were with them elsewhere on Sunday, where the theft is supposed to have taken place. Then 2 more witnesses come on Friday and testified that the first witnesses were with them elsewhere on the Monday, when the slaughter sale was supposed to have taken place. So once it was proven on Thursday that they testified falsely on the Tuesday regarding the theft, because the second set of witnesses testified that they couldn't have been there on the Tuesday, it's been established they couldn't have been there on the Sunday, so their Tuesday testimony was shown to be false regarding the theft. they were no longer valid witnesses. Well, they weren't qualified to serve anymore as witnesses. So their testimony on Wednesday regarding the slaughter didn't constitute testimony by witnesses. So the question is, if that's the case, then why do they have to pay for being exposed as zomamim on the slaughter? Because what we are saying is, in order to be having to pay Adam zomamim, your testimony has to be valid. And the testimony on the slaughter certainly wasn't valid if it was invalidated, because the minute the theft count falls away, number one, there is no case of slaughter or selling the animal, because it could be your animal you're slaughtering or selling. That's the one aspect. The other aspect is that, so we're saying retroactively, the slaughter should be thrown out as far as that's concerned, because that testimony happened at a later juncture. So when the testimony showing that their claim of theft was thrown out, there's no longer a case of slaughter, because it could be their own animal they're slaughtering or selling. So that's definitely thrown out, even from a retroactive perspective, because the testification to the slaughter occurred one day after they're testifying about the theft, because the incident, according to them, was that the slaughter happened on a Monday and the theft happened on a Sunday. Does that make sense? So
Dustin, Damon, sorry, it sounds loopy. No, I apologize. So this is the same set of witnesses, just to make sure I understand you, because I'm backing to follow. That's my fault, nothing to do with you. It's the same set of witnesses that witnessed the theft and that witnessed the slaughter. So they're correct. So they came a day later. So it's a slightly different example to what we've done in the past, where it was a separate set of witnesses. So the first set of witnesses, they were lying, and it's the same set of witnesses. They lied twice, basically.
Correct. So what's the question? So what's the question that the Gemara is asking? That's what I'm asking. What's the problem here? I mean, what can you see is the problem?
What with the same set? Well, firstly, the same set of witnesses you can't have the same set of witnesses, because it can be absolutely in cahoots. It's a problem to have the same set, I would think.
Well, the witnesses are what they are. In other words, sometimes you have somebody witnessing. It's unlikely that the same group of people that would witness the theft would witness the slaughter or sale, because they'd have to conveniently be at the right place at the right time twice. I agree with you. It might be suspicious, but the reality is, if it's your next door neighbor and you're a peeping Tom, you'll probably see it. So this is the question of the Gemara. Now, if it should enter your mind that a conspiring witness is disqualified retroactively from the moment he gave his false testimony, then these witnesses, since they were rendered zomamim on their testimony regarding the theft, it has retroactively been revealed that when they testified about the slaughter, they were actually disqualified from testifying. So the question of the Gemara is that we understand if it's in one sitting, because if the Adam Zomamim penalty would work if they testified about the theft and the slaughter on the same day, in one utterance and then to another. But here, they were two separate cases that happened to be with the same group of witnesses. So when they were invalidated by the first pair of witnesses saying they couldn't have been at the theft, there shouldn't be the reciprocal penalty for the slaughter, simply because their testimony regarding the theft was proven to be false. And if the testimony regarding the theft is invalidated, they should pay back double. But they shouldn't actually pay the two or threefold, whether they about the slaughter or selling of a sheep or an ox, because it happened at two different time junctures. So there's no testimony of which it can get a reciprocal penalty if that testimony regarding the theft is thrown out, because who's to say whose animal you're selling or slaughtering? That's the question.
But then in a way, they're lucky that they got caught out in a way. I mean, either they shouldn't have got caught out and they would have scored overall, or the fact that they got caught out in the first one, because then their penalty is only double in total, as opposed to being 2 plus the 3.
You're correct. But then the Gemara says, so then why do they pay for being exposed as Zomamim on the slaughter? In other words, the punishment for Zomamim witnesses applies only to witnesses who gave false testimony. So hence, when the witnesses were disqualified at the time they gave their testimony, they're not subject to the Hazama penalty, because being accused of falsely accusing the innocent witness, the innocent defendant of theft, means they struck off the roll. So how could they testify to the slaughter or sale, and why do we make them pay for it? So guys, you understand the question. The Gemara's answer is as follows. The Gemara answers, they said that what are we dealing with here? With a case when they were first rendered Zomamim on the slaughter and then rendered Zomamim on the theft. So that actually makes sense. In other words, they were exposed as Zomamim, conspiring witnesses, on the slaughter on the Thursday, okay, and not exposed as Zomamim on the theft until Friday. So it means in the actual case, at the time they were exposed as conspiring witnesses on the slaughter, they had not been revealed to have been disqualified when they testified about it. Hence, they are subject to Hazama. So what it's saying is here is that you could have a case where it's the same set of witnesses, but when they said they were witnessing the slaughter or sale of the animal, there's a group of witnesses that hear this in the town square and say, no, that can't be the case, that they viewed it, because they were with us. So the Gemara is saying they were actually accused of being conspiring witnesses on the slaughter first. So therefore they owe the reciprocal penalty on that, because their testimony on theft hadn't been invalidated. And therefore they try to get that other person to pay a 4 or 5-fold, so they pay it. It's only afterwards that the witnesses come and say they weren't at the theft either. They were somewhere else. But therefore, they never cancelled themselves out. They didn't get the windfall, Gavin, and therefore they have to pay the 4 or 5-fold penalty. That's what it's saying. Makes sense. Okay. All right. Any questions, Kevin? Does that make sense to you?
The way you say it, I won't be able to explain it.
All right. All we're saying is, if the order of them being caught for lying occurs with the witnesses where they said they were meant to be viewing on the Monday the slaughter of the animal, and the witnesses come to them and say, but you couldn't have been there with them on the Monday, you were with us at the movies. They hadn't been invalidated for being lying about the theft. So since they were invalidated about lying about the slaughter or sale, they're eligible for the 4 or 5-fold payment, depending if it was a sheep or an ox, and they have to pay it. It's only afterwards when the witnesses come and say the theft never took place at all, it's too late. The Adam Zomamim now have to pay the 4 or 5-fold, because the order is that the witnesses testifying to the slaughter were caught out lying about that before the theft. Very straightforward. Okay. Okay, so then there's another question that arises. Is the Gemara says, all right, but the challenge still hasn't gone away, because in the final analysis, when they are later rendered Zomamim, conspiring witnesses on the theft, it's retroactively revealed that when they testified about the slaughter, they were actually disqualified from testifying. What do we mean? Is although when they were convicted on Thursday of testifying falsely about the slaughter, they were not yet known to have been disqualified. Once they exposed on Friday Zomamim regarding the theft, it's been revealed that they were in fact ineligible to testify about the slaughter. Hence, the earlier conviction for Hazama regarding the slaughter should be set aside. In other words, what we're saying is, when all the facts are revealed, it's saying that it might have been the other way around, but at the end of the day, they weren't eligible, because the minute it became clear they were lying about the theft, why should they actually then pay for it. So the Gemara answers, the law is that the ruling stated in the Mishnah applies only when they testified with respect to theft and slaughter at one time and were subsequently rendered zomamim on both the theft and the slaughter. Okay, so what does this mean? So look, the Gemara occasionally introduces its answer, the expression the law is. What it actually means is, accordingly, the law must be that the Mishnah ruling applies only in this following case. So, for example, they testified on Tuesday, listen carefully, guys, they testified on Tuesday that the defendant stole the animal on Sunday and slaughtered it on Monday. Since they testified about the theft and slaughter at the same time, even if we disqualified them retroactively for their testimony about the theft, okay, they are still considered to have been qualified witnesses at that time they testified about the slaughter. Because there's a law that if a witness can retract his testimony within the time of an utterance. What does this mean? A false witness, therefore, is not disqualified for giving false testimony until this amount of time has elapsed after the conclusion of his testimony. So accordingly, when they testified to the theft, immediately afterwards, they said within a quick time of an utterance, they were talking about the slaughter. And they were qualified to testify, even though afterwards it was established that they lied about the theft. So therefore, they're subject to the hazama penalty for both parts of their testimony. Okay. So nevertheless, we must say, as in the Gemara said before, that the Mishnah speaks of a case when they were first exposed to zomamim on the slaughter and only afterwards on the theft, according to Rashi. Because if they'd been found zomamim on the theft first, the testimony regarding the slaughter would immediately have been rendered irrelevant. Since if there's no theft, there's no slaughter.
There also can't be any penalty then.
Pardon?
If there's no slaughter, there also can't be any penalty either.
No, they can. Let me finish. Let me just finish the sentence, Putty. What we're saying is they do have to pay double for the theft, but not for the slaughter if it's in two separate utterances. But you knocked my train of thought. Give me a minute. Just a minute.
Sorry.
No problem, mate. No problem. So what we're saying is here is that Rashi still says that they must be first exposed to zomamim on the slaughter and only afterwards on the theft. Then they are eligible, exactly as Gavin said, for the 4 or 5-fold payment. But if they were found zomamim on the theft first, their testimony regarding the slaughter would immediately have been rendered irrelevant, because if there's no theft, there's no slaughter, as we learned in the Mishnah. They would still be then eligible for the double payment regarding a theft. He shall pay double. So when they later found to be zomamim on the slaughter, they couldn't be held accountable for it because they weren't qualified to testify on it. So also what we've got to realize is this recent case we learned is if it was not in one utterance. In other words, guys, if there was not the statement of theft and slaughter within one courtroom sitting, it's different, because you could then see it as being thrown out for the slaughter, being eligible for the slaughter part, because the witness is saying, hey, they weren't at the slaughter. So then we make them pay the reciprocal 2 or 3-fold, depending if it's a sheep or an ox. Now, afterwards, witnesses say, oh, we heard that such and such lied about that. By the way, they lied about the theft. And then in that case, you could make them pay the 2-fold for that, because the order was different, because the case was heard at 2 separate occasions. But if it's heard in one day, it was theft and slaughter. In the minute a false witness has come about about their testimony regarding the slaughter or the theft, they don't get the benefit of the doubt. Either way, they have to pay the 5-fold penalty. Rashi doesn't agree. Rashi says that they wouldn't have to. They'd only have to pay in the theft, exactly as Gavin said, because even though it was within an utterance, the theft part would come to create null and void the payment with the slaughter. There is, as to summarize, a couple of things. In order for witnesses to be held accountable for their false testimony, they must be qualified to testify at the time they gave the testimony. So what did we learn before? Is if there are two witnesses against one, it cancels them out. If they were accused of robbery, they're not eligible for witnesses, or gamblers, etc. So they must be qualified to testify as far as that's concerned. And also that their testimony must still be relevant at the time they are exposed as Zomamim. So accordingly, we must say that the Mishnah speaks of a case where the first witnesses testified regarding both the theft and the slaughter at the same time, meaning on the same utterance, virtually after each other, within that same court appearance, not 2 days later with a new part of the trial or another accusation. So that makes them qualified to testify about the slaughter. But when they were proven to be Zomamim on the slaughter first, and only afterwards about the theft, so that each testimony was still relevant at the time, they were exposed to Zomamim on it. And then Rashi's understanding of Abaya's position is that obviously there would be the fact that there would be full payment if it was the slaughter first. Rashi also adds that it's not necessary for the testimonies exposing them as Zomamim on the theft and slaughter to have been given at one time. He says as long as the slaughter is exposed before the theft, they can be held liable on both counts. For that reason, Rashi rejects that alternative reading that says that both events were given at the same time, because if they were given at one time, according to Rashi, this would render the first witnesses liable on both counts, even if the Hazama was mentioned first. Because what would happen is in one utterance it would be given, and basically the false witnesses would come afterwards. So therefore they were in a pickle already. It came out their mouths. Do you get what I'm saying? Yeah. Guys, if there's any confusion, please ask me.
I think I'm okay.
All right. So what we are saying is, Kev, is that if on Tuesday the same set of witnesses said on Sunday this guy stole an animal, okay, and then on the Wednesday they said he slaughtered it on the Monday, they came back and they testified it. All of a sudden on the Thursday, somebody came and said these witnesses couldn't have viewed the slaughtering on a Monday because they were with them at the cinema. Then in that particular case, they would have to pay the threefold or twofold payment. At that point, they're not eligible for the double payment because this guy still could be a genuine thief. When afterwards there was witnesses on Friday that said there was a lying about them being at the theft, they would then have to also pay the twofold. So there are cases where you pay the threefold but not the twofold. Now Mishnah talks about it, where somebody thought they'd get in on the bandwagon, they didn't like the guy, but he was a thief. So they thought, let him pay the max. So then the thief in that case, if it wasn't found to be false, would pay his double. And in that particular case, the conspiring witnesses with regards to the slaughter or sale, if it's a sheep, would pay twofold. If it's an ox, would pay threefold. In this particular case, they were caught out, these conspiring witnesses, as lying about the theft, but they'd already been caught out first with the slaughter, so they paid the threefold for the slaughter. And then afterwards, when the witnesses were caught out, been lying about the theft, they pay the twofold. So that's when the Mishnah says they pay the four or fivefold, exactly that. But if it was done in one court sitting, where on the Monday they came to court and the Tuesday they came to court and they said, yeah, Sunday he stole it, on Monday he slaughtered it. Then what happens is on the Wednesday, witnesses came and said, yeah, no, they weren't with us. In that particular case, if it was in one utterance, many of the poskim say that if their testimony was in the same sitting, they pay the full four or fivefold penalty. Rashi doesn't agree. He said the slaughter would have to come first. In other words, the witnesses would have to say that they weren't there to view the slaughter. Sorry, because if the witnesses said that they weren't there, the first set of witnesses to view the theft, it doesn't matter if it's one utterance. If there's no theft, there's no slaughter. That's all. Right. Okay, everybody's tired. I wish you a good night, guys.
Thank you.
Chag Sameach.
All right.
Yeah, Chag Sameach.
Shabbat Shalom.
Yeah.